A Morrison man convicted of sexually abusing two of his granddaughters is currently under house arrest, and that's because of a plea deal with prosecutors. Charles Von Holton was initially charged on multiple counts of predatory sexual assault. News 8's Nina Burns joins us live in studio with more on this plea bargain.
Yes, John, Charles Von Holton's initial charges date back to 2018, but it wasn't until August of this year that he was granted that plea. While Von Holton is the latest sex offender to get off with no prison time in Whiteside County, he is not the first.
We want justice.
It's telling people in Whiteside County, little girls, little kids, shut up, don't talk.
Being sexually assaulted and abused by my grandfather at a young age is too good over my life.
A family's fight to stop a plea bargain.
That's when we hired our attorney to try to delay them, because once the gavel goes down, it's done. And so we were trying to kick that out to have time to protest.
We want justice! We want justice!
Turned into a community effort. Dozens writing in letters.
One letter writer questioned how a defendant charged with a Class X felony could receive probation. The prosecutor makes plea agreements with defendants. I do not control which charges the state pursues and which charges the state dismisses. The state is dismissing counts 1, 2, 3, 4, 5, and 6 of the second amended information.
We want justice! We want justice!
We knew pretty much what was going to happen, but there was always hope.
Now the only thing separating Chad and Arminda Von Holton's daughter from her sexual abuser is this fence.
So they're out playing and he's outside.
It's the result of a plea bargain by Whiteside County State's Attorney Terry Costello.
He literally dropped all 6 rape charges.
Sentencing the victim's grandfather, Charles Von Holton, to 180 days of house arrest after the plea dismissed all 3 Class X felonies and all 3 Class 1 felonies, charging Von Holton on 2 Class 2 felonies.
Did you make it clear to the courts that you guys shared that land right there when they decided to give house arrest?
Yeah, they knew that, and we were told by Costello that he couldn't help where we lived. Why didn't we get justice when we were doing the right thing? It's very hard for children to understand that.
The victim's family is asking why, the community is asking why, and now we're asking the same question. Why, after 4 years, does someone dismiss 6 charges, 3 of which were Class X child sex felonies? We did reach out to the state's attorney for a comment multiple times since we started covering this story back in April. That includes phone calls, emails, and waiting inside of his office. Sadly, each and every one of those attempts were unsuccessful. That's when we reached out to former prosecutor of 8 years and current law professor at Northern Illinois University, Daniel McConkey, who not only reviewed Von Holton's plea, but 5 other plea bargains Costello gave sex offenders since becoming state's attorney in 2017.
In Class X child sex felonies, I would expect to be seeing typically sentences of at least several years in the Department of Corrections.
Prison sentences that didn't happen in cases like Eddie Douglas, a man charged with 2 Class X predatory criminal sexual assault felonies and a Class 2 aggravated criminal sex abuse felony.
That's a Class X felony, again, the most serious felony. After a year and a half, that case was pleaded out for 180 days county jail on charges that would have ordinarily gotten at least a 6-year prison sentence. And I couldn't tell why from the file.
Or Terrell Walton, charged with 2 Class X predatory criminal sexual assault felonies and a Class 2 aggravated criminal sex abuse felony.
The Class X felony was dismissed and he pleaded it down to a Class 2 felony for 180 days in jail and 4 years of probation.
Ronald Gray, charged with a Class 2 felony for aggravated sexual abuse on a victim over 60, a Class 3 aggravated battery felony, and a Class 4 criminal sexual abuse with force felony.
Mr. Gray got 30 days of home confinement, and all felony charges were dismissed. The next file I reviewed was for Julio Rosas,
charged with 3 Class 2 felonies on aggravated criminal sex abuse on a victim under the age of 5.
That was a Class 2 felony, aggravated criminal sexual abuse. In that case, that should have ordinarily gotten a sentence of somewhere between 3 and 7 years in the state prison, and he received a 60-day jail sentence in that case. The case went on for almost 2 years.
William Kramer, charged with one Class X predatory criminal sexual abuse felony and a Class 2 aggravated criminal sexual abuse felony.
That case dragged on for about 3 years, and he was in custody during that time.
Costello's plea dismissing that Class X charge, granting Kramer 731 days served on a 4-year prison sentence.
I would just be interested in knowing if the state thought it was such a serious case initially, why it was pled out for essentially for time served and a lower Class 2 felony instead of the higher Class X.
And Charles Von Holton. Is that common in these kind of cases to need to go and hire your own attorney?
It's not common, and most of the time that relationship goes okay. So it signals a real breakdown in the relationship for the victim's family to get their own attorney to essentially be at odds and fighting against the state's attorney. That's unusual. In cases of great public importance, prosecutors should be giving some explanation about why they're doing what they're doing.
Mr. Costello, do you have any comment on Charles Von Holton's plea bargain?
No.
No?
Nope, thank you.
This isn't the first child sex abuse case that you've pled out for 0 prison time. Is there a reason for that, or can you give the public any explanation?
Prosecutors are public servants. They're elected officials.
Is there a reason you're a public servant and you refuse to give public comment?
Ma'am, I'm on my way into work.
And they should be reasonably transparent about what they're doing. The assumption is cases are going to get pleaded out. But having said that, the state's attorney should be only bringing charges that he or she believes can be proven in court.
Why do you think he would start off with such strong charges to then 4 years later drop nearly all of them?
Because this is what he saw in the video. That's what he saw, that were the real charges.
On that video is their then 5-year-old daughter's interview on her sexual assault.
He seduced her into a room, did everything on his own. Nobody was around, him and her, and it was a 5-year-old girl. And I believe a 5-year-old girl that has no idea about that kind of activity, to say the words that she did, I didn't teach her. So, and that had to come from her. So you got to believe them. They don't just make this up.
Once that gavel goes down,
there's no discrimination when it comes to this kind of evil.
Charles Von Holton's electric monitoring and house arrest expires March of next year. John.
All righty, thank you, Nina. Now, aside from house arrest, Charles Von Holton's plea includes 48 months probation and a fine.